Where'd he go?
He's hiding.
Ms. Cernova,
Here.
Mr. Souls, Mr. Pusilides, Mr. Beck,
Here.
Mr. Sutton,
Here.
Mr. Reichel.
Present.
Thank you. Some of our members have additional roles. First of all, Tia Cernova is an alternate who replaces anyone who is unable to show up and/or anyone who cannot vote because they have a personal issue with a particular bid. Mr. Beck is the vice chairman, and Thomas Ferrara at the far left is the zoning director for Plain Township, and I'm Jeff Sutton. I am the chairman of this group. Are there any changes to the agenda as printed?
Nope.
If none, the agenda stands as presented. Statement of duties, I will forego reading those. May I hear a motion to approve the minutes from June 5th, 2024?
I'll make a motion, Mr. Chairman.
I'll second.
It's been moved and seconded to approve the minutes from June 5th, 2024. Roll call vote, please.
Ms. Cernova,
Yes.
Mr. Reichel,
Yes.
Mr. Beck,
Yes.
and Mr. Sutton.
Yes. The motion carries, the minutes are approved. There is no unfinished business from the prior meeting. We have two appeals tonight. First off is appeal number 1393-24. It reads as follows. Applicant owner Joseph Namath, P.O. Box 427, Akron, Ohio, 44309 / Joseph and Helen Namath, 5430 Middle Branch Avenue Northeast, Canton, Ohio, 44705. Applicant is requesting a variance for a home occupation at 5430 Middle Branch Avenue Northeast, Canton, Ohio, 44705, parcel 52-17924, section 702.2 B4, conditionally permitted uses, home occupations subject to subsections 115, 122. The property is zoned R1 Single Family Residential District and is located in the northeast quarter of section 23. The fire department has reviewed the application, and for this zoning issue, the fire department has no comments or recommendations at this time. Would I have someone who intends to speak in favor of this, please step forward to the podium.
Good evening. My name is Ryan Skidmore.
Please step up to the podium,
My name
raise your right hand.
Okay.
You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please state your name and address.
My name is Brian Skidmore. My office address is 655 West Market Street, Akron, Ohio. I live in Medina, Ohio, on Granger Road.
Thank you.
Sure. Yes, I'm an attorney. I'm here on behalf of the Namaths, and so I reviewed their application and the paperwork with regard to their application in this matter. Done some work on the history of this property. I have some public records that I'd like to put into the record and have you all take judicial notice of them because they are public records. Their deeds, articles of incorporation, the liability company that now owns the property. I think there was some permitting that went on with regard to this property, and I think the complaint, at least one, from an adjoining landowner. Those are in here, they're public records. As a quasi-judicial body, you can and often do take judicial notice of these documents because they are filed either with you, the Ohio Secretary of State, or the Stark County Recorder. So if I could approach, I'd like to distribute them too, if that's okay.
Sure.
There's not all that many of them, but there are, I believe, 15 exhibits. The significance of them are the fact that they establish ownership of the property dating back to 1955. And so the way that I read the Plain Township zoning ordinance, the resolution rather, is that the application is for a variance. However, home occupations, as I read the ordinance, are as a matter of right if all requirements are met. And so I think that my clients, as owners of this property, do meet those requirements, but for two. There is a person who lives outside of the home who participates in the home occupation, and there is an accessory building. However, that's what, if all those requirements were met, they would be entitled to use the property and that home occupation as a matter of right. Because two of them are not met, then they have to make application for conditional use certificate. And when you go to subsection 115 under Article 11, those relax the requirements of a home occupation. And so when it gets to the use of an accessory building, that is permissible under subsection 115A, and it allows for a non-resident employee to participate in the home occupation under subsection 115C of Article 11. So that those provisions relax somewhat the requirements of 602.32. So I believe that the property does comply. I believe the testimony will show today that it does comply. However, there's also an interesting wrinkle in this matter because of the fact that the property was used in the same way it's being used now, and actually a more obtrusive use, going all the way back to 1955. And we have the prior property owners here this evening to testify to that fact, because the property was used as by an excavator who lived there and used the property in that manner beginning in 1955. Well, that predates any zoning ordinance or resolution for Plain Township. There was one in 1960, I understand, but there is no copy of that. The next one was, I believe, January of 1995, and then the current one, which is April of 2006. So, but this use predated even the 1960 ordinance, and it definitely predated the 95 and the 2006 resolution. So my contention is it's a non-conforming use that was in existence from even before my clients owned the property, and for that reason, it's permissible. The property was used in that manner for 69 years, so between 55 and that. So in any event, we're prepared. As I said, I put these exhibits before you. They are a number of deeds and the parcel map, which you referenced. The parcel number at issue is 52 17924 5430 Middle Branch. And if you look on that parcel map, which you may have in your file already, you can see the driveway that comes off 55th Street, and that is what is used from time to time, but on a limited basis in terms of a vehicle and a trailer going in and out of the property. So I was not the prior owner of the property, so we have those folks here, and I assume that you would like to hear their testimony.
Yes, please.
So how would you like us to proceed? Is it, I'm sorry.
Does anyone have any questions for this gentleman? Does anyone else wish to speak in favor of this bid?
Yes, I do. Am I permitted to ask them questions, or do you have, how do you, I just want to ask you how you'd like to proceed with regard to that.
Let's let them,
Okay.
and then we'll ask.
Very good.
Deal with it.
Thank you very much.
hand, please. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Your name and address, please.
My name is Wayne Paul. I live at 6482 Harness Circle Northeast, Canton, Ohio, 44721.
2-1.
Thank you. Go ahead, sir.
I'm Charles Coble's son-in-law. And we moved in 5442 in 1975. We built a home there. But prior to that, Charles, or Charlie as we call him, had an excavating business since 1955, 56 in there. It's the reason he bought that property. He had 5 acres there. I had 2 sister-in-laws that lived adjacent to the easement, and I lived west of the easement. Charlie used that driveway probably 6 times a day. He'd leave, well, 3 times a day really. He'd leave in the morning, come back for lunch, leave after lunch, and come back when he was finished at the end of the day. Stored his equipment there, which was 2 bulldozers, front end loader, backhoe, trailer. I think that's all the equipment he stored there. Being a relative, when we got the property, we just naturally used that easement there. Charlie took care of it. He put the gravel on it, and we just used it. When he passed away, I think in 92, my mother-in-law lived there for 4 more years, I believe, but she passed away in 96. When she passed away in 96, we showed the house to somebody, and they said they wanted to put a driveway off a middle branch between our homes, 5430 and 5442, and he was going to put an allotment back there. So what I did, my wife was the executrix. So what I did, I took, I think it was 28 feet. So it eliminated any possibility of going back there off a middle branch. And at that time, I offered the 2 neighbors the same amount of property behind their property, which would have squared off all the lots, and it would have eliminated the easement to that house. The deal was if they paid for the surveyor, I'd give them the property, or we'd give them the property out of the estate. They elected not to do that, so it kept the easement open. Any questions?
Any questions?
None so far.
We raised, well, my sister-in-law lived on the east side of the easement, had 3 children, and we had 2 children raised there. From the time they were 5 or 6 years old till they graduated high school. It was not a problem for us having that easement there.
Okay. Anything further, sir?
Not that I can think of unless Mr. Skidmore wants to ask me something.
Is there anyone else who has anything to say in favor of this request?
Yes, I did, just so it's clear, if you don't mind, am I permitted to ask a couple questions here?
Sure.
Okay, just so we're clear in terms of the parties, because this does have something to do with the documents that you were provided. Mr. Paul, your name is
Wait and see.
Wayne C. Paul, okay. And you were the son-in-law of Anna and Charles Cobalt, is that correct?
Correct.
And your wife, Patricia, what, their daughter?
Correct.
And she's sitting here to my right, correct?
Correct.
Okay. So you witnessed the way that they utilized, the Coballs utilized the property beginning in
Correct.
1954, 55, 56?
And I periodically worked for Charles.
Okay, gotcha. Okay. And you moved into 5442 Middle Branch when?
1975, we built a home there.
Okay. Okay. Did Mr. Cobalt ever cease using the property for his excavation business?
He worked up until 6 weeks before he passed away.
Okay. And after he passed away, did the equipment remain on the property?
For a while it did until I sold it.
Okay. And, okay. Very good. And then the property was ultimately sold out of your mother-in-law's estate, is that correct?
Correct.
Okay. All right, very good. I have no questions, thank you.
Could I say something?
Yeah, you're next, hang on.
Oh. I was just gonna say, that easement, we had a long driveway out of our garage. And we come in the easement into our garage, okay? But the ones on the other side, they don't actually have a driveway. The property just comes at the end of the easement. So if they block that easement, they're not gonna have a driveway. Do you understand what I'm saying?
Yeah.
Because the driveway was on the side. But that's all I got to say. So if you block it off, you're blocking them off.
Okay.
And she's here tonight.
Anyone else have anything to say in favor or against this appeal?
Well, I think the Nemas do.
Excuse me.
Yes, you can have a seat.
I think Mr. Nemeth is for, so maybe we should get the for first. Speaking for the,
Yeah, four. Anybody in favor first? Yes.
Right.
Please state your name and address, please.
Joe Nemeth. My address is 2383 Graybill Road, Uniontown, Ohio.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
No, the only, I don't know what to add to this, but when I did purchase the home, I was the one that purchased the home, and I talked to Wayne about it, and I really liked the driveway going in. I said, this is gonna be good for, because we were buying and selling homes, and me and my brother had an electric and plumbing business going. So he said, yeah, I don't see any problem with it, you know, you've been using it this way forever, so that's what I did, starting in '96. And then I built one garage in '99 and the next garage in 2008. And you guys, I think Tom was there for the 2008.
I think it was 10.
Oh, was it 10? Okay, 2010? Okay. He was there for the second building of the garage, which I had to get a variance for, and he saw, you know, we had two garages and saw the equipment there. That's all I have to say, really. That's the reason I bought it. I've been doing business there since '96. Some of my equipment is there, you know, at the store or whatever. That's it.
Okay.
I have a couple questions just for your benefit, if that's okay.
Yes, sir.
Yeah, so you were involved, you are Joseph D. Joseph D. Nemes, is that
Correct,
Okay.
yes, Joseph D.
And so you are the son of Joseph M. Joseph M. Nemes,
Yeah,
correct?
that's
Okay.
correct.
All right, and you were involved in the purchase of 5430 Middle Branch in 1996?
Wait, the purchase of, sorry.
I'm sorry, 5430 Middle Branch in 1996?
I was, yes.
Okay, and so.
He had a sign out front, and I checked it and talked to him, and, yeah.
Okay, so so you were familiar with how the property was being used prior to your family's
Oh,
purchase?
yeah.
Okay. And you knew it was being used for an excavation business?
I did, yes.
Okay, and you knew that the easement?
I knew from what he said, you know, I didn't know from anything else, but I
Okay.
asked this gentleman, Wayne Paul.
Okay, and then, so then you, what was the access from 55th Street, that easement from 55th that ran back to 5430 Middle Branch, was that important?
Well, it is to get to the backyard and where the garage is, yes.
Okay,
So, wait, guys, I gotta be able to hear you.
Oh, you mean, okay.
It is, and then I didn't hear your answer.
It is important because that's where we store the trailers, is in the back or whatever, with supplies or whatever, you know, was going on. And we didn't want, you know, no access to the backyard from the front yard, because it comes into the house, the driveway. And I thought that was a selling point, that's why I bought it.
When you purchased it when it was purchased in '96, did you live there?
I did for a while, then my parents wanted to move, and I met a girl, and so I moved in with her, and my parents moved into that house.
Okay, and when was that,
Uh,
if you recall?
99? Probably 1999.
Okay. Now, when did your, what is what's the name of your business?
Mine, Laser Construction and Joey Seamless Gutters.
Okay, and so, and you were operating that business, and for whatever purpose you were utilizing 5430 Middle Branch, that began in '96?
No. The business, the laser construction roofing business started like in, I would say, 99. The gutter business started in 2009.
Okay,
Before that, we were, I was doing plumbing, and we were buying and installing homes and building a couple homes. We built homes also.
okay. So the business of Lazar and the gutter business, that is not performed at 5430 Middle Branch, correct?
No.
So your customers are, not- they don't,
No.
they don't come to you, correct?
No.
Were your parents at all involved in the business while you were there?
Well, they loaned me some money to buy equipment, yes. And,
Did your dad work in the
yeah, he
business?
did. If we needed something, he would go,
Okay.
pick up supplies.
So as far as the in and out off of 55th Street, how many times a day do you go in or out of the property utilizing that driveway to 55th Street?
With trailers, once in the morning and once at night, but we may come through once with a car, or something. They may deliver, my dad may use it to take grass clippings or trees or something or whatever in a truck, so I personally try to use it twice a day, early in the morning and once around 5 o'clock at night. My dad may use it once a day, but it could be, they may not use it for a couple of weeks and then, but I'm basically there every day.
Okay, so your parents
5
use
days.
it for taking care of
Just this
the
stuff,
property.
yeah.
Now, when you talk about trucks and trailers.
Just one at a time.
Oh, okay.
So I can hear
Turn
both
that
of
talk
you.
on.
I got you.
Go ahead, sorry, I know it's hard. When you, yeah,
Pardon me?
go ahead, you started to say
Yeah.
when
When you talk about truck and trailer going out and then back in at the end of the day, what kind of truck?
Like a 1-ton Ford truck?
Pickup?
Yeah, just a pickup truck.
Okay, and what's the trailer?
Like 16-foot trailer.
Okay,
One gutter machine's 5 inches, 16 inch. The other one's 16 inches, a 6-inch trailer. Then we have one that we don't use very much anymore is the roofing trailer with compressors and all the roof and stuff in it. That's a 20-foot black trailer.
okay,
And then one dump trailer we only use on roofing jobs if we get
okay, so the total number of trailers that?
4.
Four, okay, and you keep any of the trucks on the property, or you just drive those home at night?
One truck stays there, plus my dad's truck, so 2
Yeah.
trucks in the back.
Okay, so you're out in the morning and back in the evening, correct?
That's correct.
And it's typically once out and once in?
Yes.
Okay.
But there's a rare case where it was photoshopped, or photos taken. She saw 3 trailers come in on one day, and that is true, 3 trailers in one day, but we were on that job site for 17 days. So I had all my equipment at the gentleman's house. It was a total siding, soffit, a lot of wood replacement, new roof, new gutters. We were there 17 days in March. I think it was March. So for 17 days, there was nothing, but on that day we came home on Monday, there was three trailers coming through.
So are you referencing the complaint that was?
Well, the one that Tom showed me a photo of.
Okay. And I would just direct the board to Exhibit 15. It's
I don't know what.
It's in the book, and those pictures are there.
Yeah,
You can see for yourself what they depict and what they don't depict. There's more that they don't than what they do. But in any event, So was it your objective at some point in time to purchase 5430 Middle Branch from your parents?
Yeah, sure was.
And have you done that?
I have.
Okay, and so who owns 5430 Middle Branch today?
I did.
Okay, well,
And that was in the works before any of this started.
okay, and that was your.
That was just because they're getting old and going through,
Okay.
getting their estate in line, I guess.
Did you form the limited liability company known as Seamless Properties LLC?
I did.
Okay, and does Seamless Properties LLC technically own 5430 Middle Branch currently?
It does.
Okay. Is there any signage on this property that relate to your business?
No, sir.
Is there any outside storage of any significance?
No, I would say no, everything's in the garage.
Is there an accessory building or garage?
2 garages.
Okay, and is one used for the upkeep of 5430 and is
Yeah, one is my mom's garage and one is my garage.
Okay. Is there any portion of the house that's devoted to your business?
None.
Okay. Do any of the trucks or trailers that are in and out or materials that are stored on the property create any offensive noise, vibration, smoke, dust, odor, heat, glare, x-ray, radiation, or electrical disturbance?
We don't manufacture or fabricate anything there. It's just a gutter machine, which when I get to that job for that day, we'll measure the gutters and make the gutters then.
Of the things that are on the property, is there a fence around it?
There is an 8-foot high fence around the entire property.
Okay.
In the backyard, from the house to the back of the property line.
So that's
Inside the setbacks.
Inside, say again.
Inside the proper setbacks.
So that is a barrier all the way around the
Yes,
property
yes.
between
And
the
with a
street,
gate, yes.
between the street and the neighbors?
That's correct.
Okay. Do you have, are there deliveries made by commercial transportation to the property that
Never.
relate to your business?
No.
Okay. I'm looking for-
Anyone else have anything to say in favor of this?
Are you done with me?
Yes.
Okay, all right.
Anyone wishes to speak against this? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
So help me God, sir.
Thank you. State your name and address, please.
My name is Hannah Miller, and my address is at 5442 Middle Branch Ave.
Thank you.
So first, I just wanted to thank you all for the opportunity to speak here this evening and hear my family's concerns in relation to this zoning appeal.
Are we in favor or no? Or we on something else? Okay, I thought we were still in favor.
No.
We purchased our current home at 5442 Middle Branch Avenue in April of last year, and have greatly enjoyed settling into the community. Unfortunately, an almost immediate concern since our move-in date has been the tremendous amount of traffic in the shared driveway bordering the entire rear of
I'm
our
sorry, the
property.
amount of traffic and,
The amount of traffic in the shared driveway boarding the entire rear of our property. Our almost 3-year-old daughter, Judith, who is here this evening, is the center of our world, and her safety is paramount to us as parents. Large trucks with trailers quite often speed down the driveway daily when the weather is amicable, putting her safety at risk as she plays outside. I have tried to request to my neighbors that this traffic slow substantially, and even put signs in my yard stating to slow down and that pets and children live and play here. As I understood that this could be used to them, as previously the home was owned by senior citizens, is my understanding. Anytime I approached my neighbors to try and resolve this civilly with no intervention of the township, I was met with, "I thought I was going slow enough." I felt the safety of my child at her own home was of no concern at all to them. Our intention of contacting the township was not to dismantle a business. We have no desire to jeopardize anyone's livelihood. Our simple yet profound concern is the safety of our daughter, as well as other young family members who frequently enjoy playing at our home. My husband and I fully acknowledge that we are the persons primarily responsible for our daughter's safety, but as the saying goes, it takes a village, and we wish to eliminate the increased possibility of a terrible accident happening. If at all possible, I would at least request a compromise so that my daughter remains safe and that my neighbors can continue to support their family. Perhaps in the way of a 4-foot chain link fence that does not limit visibility could be put alongside the shared driveway from the wooden fence's gate to the entrance of our driveway at the expense of the business or property owner. Or simply, they could find another way to access the property. Thank you for this opportunity to share my family's concerns.
Thank you.
Anyone have any questions?
I do, but I'll hold until the end. I have no questions of you right now.
Thank you, sir.
I did have a couple of
Oh.
questions, if that's okay. And I'll be brief, and Ms. Miller, I appreciate your testimony and your concerns, but if I understood what you said correctly, you just lived there for a year, right?
We have lived there now for just over a year, correct?
But you had made complaints within the year, right? Or about a year?
I would have to look back to see when I emailed Tom Ferreira. Again, not really understanding, just having a concern of safety, not even knowing what the zoning laws are in Plain
Okay,
Township.
I appreciate that. Obviously, you looked at the property before you bought it,
Yes, sir.
and you knew that 5430 being next door had access both from Middle Branch but also 55th, correct?
I could see the driveway. The purchasing and the current environment of home buying and selling, the decision had to be made very quickly. So it didn't have the opportunity to review traffic of the property for weeks at a time, certainly.
Okay.
But did see that there was access to a gated fence,
Okay,
yes.
and that's pretty clear, isn't it?
Yes,
Okay. And you've not seen these trucks emit any offensive noise or vibration, smoke, dust, odor, heat, glare, X-ray radiation, or electrical disturbance, have you?
I mean, when they do go at a rapid rate, dust can be let off as it is a gravel driveway. So that can be a concern, but my concern is the trucks going at an accelerated speed with large trailers behind them, and the safety of my almost 3-year-old child.
But you wouldn't let your child wander near a driveway of any kind?
Of course
Or
not.
a street, right?
Of course not, and if you've noticed how our entire property is formulated, there's not a whole lot of places besides our backyard to have a child play safely.
Okay.
However, accidents happen.
Mhm.
I absolutely am responsible, and any caretaker that I deem responsible for my child during business hours or outside of business hours has the primary responsibility of ensuring our child's safety.
In your complaint, you made reference to commercial trucks, and these are just pickup trucks that you'd see driving up and down the street, correct?
Commercial, in my definition, would be intended for business, not for personal use, as I am in the insurance business.
But you couldn't look at it and tell the difference, right? It's a pickup truck.
I could tell due to the timing and because of what they were hauling, that they were not used for personal
But
use.
the appearance of the truck alone does not indicate a commercial use, does it?
It intends that it is being used for some type of work.
And if it's not pulling a trailer, your assumption is it's being used for work, is that correct?
Without the trailers, there would not necessarily be a way to indicate that except the number of people inside.
Thank you. I have nothing.
Any further questions?
I should say something.
I guess I have
Yes,
one.
we raised our kids there.
She brought up a shared driveway.
They were babies, Wayne. They didn't.
Wait, one at a
Yeah,
time.
wait, ma'am,
I thought,
let's
She wanted-
let's stay in sync here for our recorder
Yeah.
over here, okay?
okay. I didn't know she was.
Do you have a question for this woman here?
Yes, I do.
Okay, please state your question to her.
Oh, my question, well, it's a general question. She made the assumption that it's a shared driveway. I don't know, I'm not a lawyer, but it's not a shared driveway, it's my property. I pay the tax on it, right? There's a difference between a shared driveway and my property.
My understanding is the driveway is also owned by another neighbor whose address is on 55th, that the driveway is shared. I know that I do not have any legal ownership of that driveway, but it is indeed a shared driveway.
Yeah, the land she's speaking of is not, is mine. I pay the tax. So, correct? I don't,
I'm not-
I guess
yeah,
I
I'm-
refer a question to Mr. Tom Ferrera. That is not shared driveway, Tom, correct?
I have no idea what,
Oh, you don't know it?
the deed would have to show
Yeah,
if there was a
Do
shared.
we have deed in there?
for the benefit of the board, I'll just interject that the easement document is in the materials.
Okay, I didn't know, because I bought properties, bought and sold a lot of properties, and the shared driveway is a little bit different than me actually owning my own land.
I don't intend to use a legal definition as an
Understood.
anonymized,
Understood.
but 3 neighbors utilize this driveway shared between us on a daily
Thank you.
basis.
Any further questions? Yes, sir?
All right, I'm Mr. Nemus Senior.
Please come up to the podium,
Wait a
sir.
minute.
Yeah.
Okay, you can sit down.
Thank you.
We're done with them.
Please come up to the podium, sir. State your name and your address.
Wait a minute.
Yeah.
You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Please state your name and address.
Thank you, Mr.
My name is Joe Nemus Senior, and my wife and I raised 5 kids. So I am well aware of a child's safety.
Address, please.
5430 Middle Branch Avenue, Northeast.
Thank you.
And we raised 5 kids, and I am well aware of a child's safety. It's the first thing I look out for. And we do use the driveway, but not every day. And she posted 2 signs here, beware of kids playing. So we drive in that driveway about 10 miles an hour,
Not that fast, I'll tell you that.
5 miles an
I
hour,
was going 4 of them.
very slowly. And this child has a swing set up in her yard. It's about 30 yards from the driveway. It's not close to the driveway. So we drive very slowly. I look around, see if I see any kids. That's my first thought, is child safety. And in no way that we would go up and down that driveway fast, recklessly. So, like I say, it's about 5 miles an hour, very slowly. And the child's safety is very important to me. That's about all I have to say.
Thank you. Any questions for this gentleman?
Can I say something?
You may be seated.
Told them we raised kids there.
Yeah, but you did.
Anyone else wish to,
I'd like to speak.
You can sit down.
please be seated. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and address.
My name is Catherine Good. I live at 2212 Hunting Valley Court in North Canton. I am the grandmother of the child in question, the mother of the young woman who spoke. I have been at the house and am at the house relatively regularly. I babysit there. I see my granddaughter. Maybe not daily, but we'll say several times a week. My husband, who is her grandfather, babysits in the beginning of the week. We have both witnessed this traffic on repeated occasions. My daughter merely wrote as a concern for her safety, and now it feels that she's going to be cross-examined by an attorney. I don't believe this is fair. This is all about this little girl's safety and nothing more. I never planned to speak today. I overheard this woman saying she raised children there. I've raised 4 children. We all have responsibility to our own children. I get it. There is a swing set there, sir, you're correct. And the child is supervised regularly. But accidents do happen, and cars do come at an accelerated speed through that very small area. And it is concerning. Whether they're going 20 miles an hour, whether they're going 15, I don't know. I don't have the ability to to gauge that personally. But I can tell you it's concerning from my point of view as a grandmother. Her great-grandmother is there every Friday, concerning for her, concerning for my husband, for both these young parents, and other people in that immediate area have expressed their concern. I don't know if they're here tonight or not, as I don't know them. But I'm speaking on behalf of my granddaughter herself, who can't speak up here today. She doesn't get this. But God forbid something happened to her. While I recognize they understand the safety of a child, we never intended for this to be brought in a zoning piece. I had no idea about the business piece. We didn't even know there was a business back there when she purchased the home a year ago. We did notice the traffic almost immediately. The weather changed. She moved in spring, and it did continue through the summer. But there was a lot going on last summer. Admittedly, they were trying to find their way through their second home, reestablish themselves. They're, again, a young family. So I'm here tonight just to support the fact that all they did was bring it to your attention that we had some safety concerns that they believed were not being addressed properly. And now she's faced to speak in front of an attorney as if she did something wrong by bringing it to your attention. And I don't think that's fair. And I wanted to share my opinion. My granddaughter means everything to me. My family is everything to me. And I ask that you just keep that in mind while we're making decisions moving forward. Thank you.
Thank you.
Can I say something?
Anyone have any questions? Yes, ma'am. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and address.
6482 Hardy Circle, Canton, Ohio 44721.
Your name,
Patricia Paul.
thank you.
My dad owned the property. I grew up on that property. My sister and I raised kids on the property. They didn't run out on the road. We watched them. My sister had 3 babies. She lived on the other side. I lived in their house. We built that house. My dad came in that road. He had a bulldozer, a tractor trailer. He would wave to the kids, and the kids would get in the truck with him and ride to the other end. It's not dangerous if you watch your kids. And if she saw that house when she bought it, she knows that road was in there. And if she is so undesirable with that road, put her own driveway on. She's got enough land to come in off of 55th Street and change that. But that property was a good property, and my dad watched our kids. And I don't care what her mom says or her aunt or whoever. Keep an eye on your kids. I mean, we had babies there. We owned the house on 55th Street on the corner and the next 2 houses down, my sisters. My dad gave us each an acre, and we built our houses there and we raised our kids until they were in college. And there's no sense, and they should block that road off. Keep the kids hitched wherever they should, tie them up if they have to. And I know she's not the only one that's complaining. The one that lived on the other side, my sister's house, she's been complaining for 30 years. She tried, we asked her to block that off when we bought our house where we moved when my mom died. And she didn't want to because she wanted to come up with money. And I'm just telling you, there's no reason for them to block that off. She wants to block it off, tell her to put a new driveway in. She got enough land down there. That's all I got to say.
Are there any questions for this witness?
None.
I do, just for clarification, your father's name was what?
Charlie Cole.
And your mother's name?
Ann.
Anna Koval?
Yes.
Does anyone else wish to speak in favor or against this appeal? Raise your right hand.
Oh, God.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and address.
Josephine Glover.
What was his last name?
Glover, Glover. 2626 55th Street Northeast. You know, it sounds like we're talking about three different issues here.
Yeah.
I mean, somebody's talking about closing the road, and I've never heard that with regard to any of the, you know, pre-information that was given out. And you all are just trying to be legal, it seems, about having your business there, correct? I mean, we've lived there on the other side of the easement since '93. And that was before they were there. Pat and her husband were there. They sold that house to us because her sister died. And these people weren't there either. Speed has always been an issue. It may not have been you, or it may not have been you, but people that work for you all, who come in early in the morning and leave in the afternoon, you know, young guys, and they have a tendency.
They have all slowed down, way down.
Yeah.
I will tell you one thing.
Wait.
No,
One person.
Okay.
one
I
person
got it, okay.
for the recorder, please,
Okay.
please.
So, you know, when they're saying that they, you know, they've tried to be, you know, respectful of the kids, I mean, we felt, you know, we felt nervous about our kids too, and our grandkids, and, but, I mean, it didn't really seem like there was anything that we could do to change it. We could have put our own driveway in because half of the easement belongs to us. Oh, yeah, it doesn't. We
No,
paid.
no,
Wait.
We're gonna put an end to this right now, okay? None of this arguing back and forth between each other. Okay, this is a civil discourse here. And I'm sorry, Mr. Chairman, but
That's all right, you just outspoke me.
yes. We're having a civil discourse here. I don't want any aspersions thrown around between individuals that are in this room right here. If we have to get law enforcement in here to keep a proper...
It's not funny.
It's not for you. It's
Oh.
everybody that are sitting here chiming in, okay? If we have to get law enforcement in here to keep everybody talking one at a time, we'll have it done, okay? Understood? Thank you.
And I would just say for the record, I talked to Tom Ferrara years ago about concerns that we had about, I think that was when they built the first garage. And then, you know, both garages are bigger than their house. Well, it's their property, just like they say. And they did fence it, and we've tried to live there, you know, and the best of our ability to live in peace. But just for the record, you know, I wanted to say that there are other people besides the Namaths who go in and out on almost on a daily basis. And those would be the people probably who are even a bigger issue than what the owners are. So,
Thank you.
Thank you.
Now, did you have something to say, sir? Sir,
I'd like to apologize for speaking up during the meeting.
thank you, sir. I appreciate the apologies. It's
But the surveyor sticks or post is 25 foot wide on that easement. That is owned by Joe Neiman. They do not own half of it. That easement comes right up to their concrete. That's the part I was disputing.
Thank you. Do we want to open it up for questions from us?
Yes.
Close it to the public.
Or the public?
Let's close it to the public.
We're closing this to the public now. We've heard enough on both sides.
Any questions from the board for anyone?
I have one, but either council or Mr. Neiman. I see in your well put together documents, I appreciate that there was an application made for an accessory or a residential structure that was in 1999. It was for a detached residential garage. In that request, there was no mention of any business operating. And with Joe Nema's signature, it stated that this was for, where did I see that? Yeah, I see that one. The other one, it stated the purpose for that building was for cars and storage. Cars and storage. On the application you made on 10/8 of 2010. Nowhere on that document does it say anything about running a business out of that structure that you had requested. Back to that statement, have you, Mr. Neiman, ever applied for a conditional use permit?
I'd just like to take one step backwards on your question.
Yes.
That 2010 garage, is it 2010? That is my parents' garage.
Okay,
The 99 garage is my garage,
okay,
and it's still just storage in there.
okay.
So there is no manufacturing or anything in there, just
Have you, again, have you ever
all
applied?
the trailers are on grass or cement,
All the trailers,
are on grass or the cement. They're outside, they're not in garages.
Have you ever applied for a conditional use permit?
I don't think so.
Thank you. I find one comment interesting too from, I believe it is it Josephine Glover?
Yeah.
No, not Josephine, Catherine.
Catherine, good.
Good.
She took my daughter out, I could have her return if you would like.
No, and you're Hannah.
Yes, ma'am.
What was this where you would be willing to compromise with a chain link fence?
It's simply a suggestion, and I don't know the possibility. Again, I am not an attorney and I'm not represented by an attorney today. I just want to reiterate, my concern was never to dismantle a business. Did not even understand that business was operating.
I understand.
My hope is that to greatly reduce the risk of accident, would be a chain link fence to be erected that would not limit visibility, because that would also be a safety concern, to be put alongside the rear of my property where that easement, shared driveway, whatever vernacular you'd like to use. So that way, a misstep from my child from my property does not end up in front of a truck.
Thank you. I have no further questions.
Any other questions from the board?
I do, I have a question, I'm not sure for who, for council or the owner. In the deed, which is volume 1391, page
say
899.
again.
Volume 1391, page 898, 899 is an easement for a driveway. And in the easement for a driveway, it lists several parties of having right-of-way for the driveway purposes. So, while I understand the driveway would be deeded to the landowner, am I correct in stating that there is an easement for other owners to use that driveway legally?
Correct, and the reason why, Mr. Beck, and all of you, the reason why I provided these materials and the reason why I tried to link up these names is so that you can connect them and see that the easement was granted by the Cobals to.
The easement was what, created?
Granted
Oh, granted.
by Anna Cobal who ultimately sold the property to my client, but the easement ran from her to Charles Albaugh and Cecilia Albaugh, who were daughters, a daughter and son-in-law, and then Mr. Paul to my right and his wife Patricia Paul, who were daughters as well, and lived in 5442. So yes, it's an easement. The owner of 5430 owns the property, but there is an easement for access into the driveways of 5442 and 2626 55th Street. Does that make sense?
Yes, thank you.
Okay.
Anything further?
I have a question, I'm a little confused. Mr. Nemeth, is it you or your parents that own the house?
Last week it transferred to my name. After,
Okay, do you have any proof of that?
We do. If you look at exhibit, I'm sorry, I don't mean to speak out of turn, but exhibit 15, not 15, it is two exhibits. 13 is the Articles of Incorporation or Organization of the House Secretary of State for Seamless Properties. Then page 29, I base stamp the pages so it's easier for reference that way as well. But exhibit 14 is a deed. It's been submitted. It's been executed and submitted to the Stark County Recorder for recording. But the consideration has been paid. It was not a gift. Consideration was paid, and this is the deed that reflects that conveyance. So we're waiting to get the recorded one back, but as you can see, it was executed, I believe, on June 12th.
The reason I ask is that the auditor's page still shows his mother and father.
I'm sure they do,
So
because
it
it
was
takes a
just
while.
transferred?
Yeah, it takes a while for that to catch up, but this has been submitted for recording, and the conveyance fee has been paid, the recording fees have been paid. This was something that was an objective in their family for a long time, and it was not done for this purpose, but it was done, so you should know about it.
And Mr. Nemeth, you bought the property in 99?
96.
96. And that's after the previous owner had died, the home was apparently vacant for a short time.
Yeah, I don't know how long it was vacant. I'd have to ask that gentleman there. I don't know.
How long after you moved in did you start the business?
This particular business or my
Business
other,
at
I have
that
had
address.
other businesses.
Business at that address.
Probably right away, you know, putting stuff in the backyard, you know, I don't. We had, you know, I was doing a lot of painting and stuff, and like I said, we were building homes. But I would say 97, you know, spring of 97. I mean, I think they bought it in the fall, I think. I mean, we're going back 28 years, I think, something like that, so, but it's a tough.
And you have nothing to show that you got, that you obtained a conditional use permit for that business?
I didn't, truthfully, I didn't know I needed one. I don't know what kind of, because like I said, I asked Mr. Wayne Paul, I said, he's using this, right, for back, I can use this backyard for, yeah, oh yeah, he's been doing it, and he has a bit more trucks than you got, and I said, okay, I didn't know all of it. I just says, okay, to use this driveway and park my stuff back. He says, yeah. I like going down in the walkout basement, showering downstairs. That's what I did. That's what he did, and that's what I did.
Just, if it's of any help, that's why I started with 602.12, which is by right, no application process is.
Which is by right.
By right, and no application process is required.
Can't hear you.
However, if all those conditions are not met, then there is an application process. Let's back up to when this property was used as a home occupation. It actually predates the current resolution, the prior resolution, and the one before that. So unless there's.
I'm sorry, could you say that again?
Yeah. The way I read the history of Plain Township zoning resolutions. The current one was enacted effective April 14th, I think, of 2006. Obviously, the property was being used in that manner. There's, for lack of a better term, there's a grandfather clause. Let's go back to the prior ordinance, the resolution. That was in 95, and the property was being used in that manner then as well. Let's go back to 1960. My understanding is there was a zoning resolution, but there is no hard or transmittable copy because it couldn't be sent to me to see what it said with regard to use of the property. Well, I think we've established here today that this property was used in a more obtrusive manner than it's being used today back in 1955, which predates any zoning ordinance that Plain Township had, the first one being 1960. So I totally appreciate the fact that perhaps, or if it's established that no application for a conditional permitted use was made, I think there's some good reason for that. There's some legally supportable reason for that. And it was certainly not intentional, but to me, it's a non-conforming use that was going on 69 years ago, and well before Plain Township had a zoning resolution of any kind.
No, go ahead.
In the section that you were reading, you said that if you don't meet those conditions, then you need a conditional use permit. Bear with me for a minute.
No problem.
Under number 9, it says, no person who is not a resident of the dwelling may participate in the home occupation as an employee or volunteer.
Correct. And as I said in open, there are two conditions here that I believe are not met. Because Mr. Nemeth Jr., Joseph D., does not live there. It also provides that there shall be no use of accessory buildings. There is an accessory building, and it is, one of the two is being used, for that purpose. So, that, I believe, takes us to Article 11 and subsection 115, because that's the conditional use, the conditional permitted use, and there's a list of factors there as well. I believe all those are met, because there is no residency requirement in 115. It says there can be an employee who doesn't live there. It doesn't say that whoever runs the business, whoever's business it is, has to live there. It doesn't say that. If it did, it would, but it doesn't. So I believe that subsection 115 is satisfied in terms of those conditions. Now, there would have to be an application, and there would have to be approval, but it does say if those conditions are met, that the certificate shall be granted or shall be issued. It's not discretionary. I think you have the power to be discretionary beyond that in terms of what should be done here. And if the parties are agreeable to a chain link fence, if that gives everybody the peace of mind that they need, and honestly, from where I sit personally, and as my clients sit personally, they mean no harm to anyone. They want to make a living like anybody else, and that's important too. But if there are terms and conditions that are agreeable, does that solve the problem? Does it solve the problem in terms of condition that you may choose to impose in order to resolve this? I don't know that we need that as a legal matter in terms of what the resolution says and what it provides, but that's all up to you.
When speaking of the grandfather, you said it should be grandfathered in.
As a non-conforming use.
In order to be grandfathered in, and to be a legal non-conforming use, it would have had to have been legal when he started the business or when he moved there.
Correct.
And there's nothing to indicate that anything was legal.
I don't know that it's limited to the date certain in which the Nemus began to use the property for that purpose. I believe the non-conforming use is going to tack on to the use that was made by the prior owner, and that was clearly in the mid-1950s.
Well, they were different uses and there was a gap in usage, so.
Well, it's an interesting point that you would bring up. However, the gap in usage, we would have to assume that the 1960 ordinance in fact provided for the abandonment of a non-conforming use for 2 years. The current one does. But what do we know about 1960? We don't know anything about it. And that's what applied prior to 1995. So that's my response to that. I mean, I've thought it out. I've read the resolution. I mean, that's the way I read it.
Anything further?
No, the use itself, as we are right now, is not a legal, non-conforming use. They don't meet all of the standards that are set.
You said
That's all I have.
it is not illegal conforming use?
It would had to have been legal back when he started. And we have nothing on record. Mr. Nemus said that he didn't apply for it because he didn't know about it.
I'll just say that I respectfully disagree that it is not a proper non-conforming use. I would not advance that argument if I did not believe that to be true. It does not begin with the Nemus use of the property.
It does not begin.
It does not begin with the Nemus use of the property.
May I have a motion, please?
Well, I'm not done yet, Mr. Chairman, with all due respect. I take pride in the fact that this board has always worked to seek a compromise when, as I see this now, we could go 2 ways with this. We could shoot this thing down, you take it to appeals, so you go up to the Court of Appeals, okay, and get the decision you want, or may not get the decision you want.
Understood?
Miss, I always get it. I want to get them right, because I wrote your names down in Miss Miller,
Mrs., but yes.
Mrs. Miller. With your ask of a fence at their expense, would you be happy with that?
Yes, sir.
A fence does not necessarily slow vehicles down.
No, but it does make sure that for that stretch where the fence is, and my daughter does not misstep in front of a speeding vehicle. And that is where the majority of my daughter's play is, because the other portion of our property on the other side of our driveway is unfortunately too close to 55th, and the other portion is too close to Middle Branch, whereas we're quite.
How many feet do you think we're talking for a fence?
Admittedly, I'm not a good person to ask. I'm not a visual person. I'm not sure how long that would be.
You know, we
I'm
could
sure.
probably look at the pictures and make
Yes.
some determination.
Mr. Nemus, you have an idea?
Yeah. Would you be amenable to that?
I'd like to put the same fence down to make it look the same as my fence.
But, yeah, you can't, because you have to be able to see through it, is what she's asking.
What, for what reason does she have to see?
For safety, and she's gotta be able to pull out. She's gotta be able to pull out too.
Oh, I see what you, yeah, that was my next point. I would love to run a fence down my property line to the street. And he didn't mention this, but there was talk of them, both houses that Mr. Cobo built for his daughters, of them having their own driveways to Middle Branch, or to 55th, I'm sorry. So I would love to run a fence down, and then they have their own driveways.
Well, you might run into an issue because Stark County is very aware of the traffic going out to streets like 55th.
Okay, yeah, I don't know any of the
And so
rules.
they at times limit
Yeah, I would just,
the driveways, so
Right.
it would depend on them.
She's only looking for a chain link, being able to see through it for safety reasons, correct?
Yes, and I would be amicable as well if you would like a fence going down the entire side of that property, as long as I would have some type of gate access to my driveway. So So if that would also be
But, yeah.
applicable to me,
I can't adjudicate that.
of course.
That-
Chain link is fine.
Stating it for the record.
Chain link is fine.
Are you agreeable to that?
Yeah, if it's not,
Why don't we come up here, let's look at the diagrams right now.
where her driveway starts and my fence starts is the length, it's about 75 feet.
Okay, let's take a look. Just so I'm clear on this as well. You know, I want to be,
Yeah.
I might have a map with
He's got the
Oh, you
same
got
one.
it, all right.
He gave me that.
What?
Guys, we can only speak one at a time.
okay, counsel, you show me where she lives, Miss
She
Miller.
lives,
Or you come and show us where you live.
right here, correct? This is 5442.
Yes, and
This
this
is-
is
this
my
is-
driveway.
That's her driveway, this is the easement, so we've got, 190 feet.
But it's not all the way to the street, so the 190 is to the
Guys,
street.
guys, guys, I have to hear every
Yes.
word that you're saying,
sorry.
please.
You are stating from here, edge of your driveway, or a few feet back to there.
That's it,
To where the wooden fence begins, yes.
right there.
Got that?
Yeah,
That's the distance that you need, that you're requesting a fence.
Yes.
Right there.
So that's about half, this is
It's, yeah, I would say it's 80 feet, I don't know.
100
About
feet,
80.
180, 100 max, maybe. Thank you.
You're welcome.
Both of you.
Thank you. So you're amenable to that, you're amenable to that. So I think, Mr. Chairman, what we would do, I will make the motion and I will modify the application by putting in there that Mr. Nemeth will provide a chain link fence from Mrs. Miller's drive, or several feet off her drive, back to the adjoining wooden fence of Mr. Nemeth. I'm gonna go ahead and read that. I'll go ahead and make a motion. Yes, sir.
One small tidbit, as you can see from the photos, for me to put the fence in, I think Tom had already addressed this, but he brought to my attention that she has a shed that's a good 7-8 feet on my property, where that fence would go. If she could move her shed, then I can put the fence, but otherwise I have to jog, her fence is on my property. I think Tom told me that, is that correct, Tom? Okay, he said yes, so.
Yes.
I'm
and,
sorry, yes.
Okay.
We are working to move the shed. It is a bit of an expense for a young family. It has been there for about, I've been told 30 years. But I am working to move the very old shed, hopefully successfully intact so we can still keep our lawn equipment. But yes, I absolutely can move the shed so that the
It's just in the
fence-
way of the fence, that's all.
Yes.
Sorry.
Thank you, Mr. Nemeth. I'm gonna make an appeal, this is bill number 1393-24, applicant owner Joseph Nemeth, post office box 427, Akron, Ohio, 44309, / Joseph and Helen Nemeth, 5430 Middle Branch Avenue, Northeast Canton, Ohio, 44705. Applicant is requesting a variance for a home occupation at 5430 Middle Branch Avenue, Northeast Canton, Ohio, 44705, parcel 52-17924. The applicable section is 702.2 B4, conditionally permitted uses. Home occupation subject to subsections 115 and 122. Now therefore be it hereby resolved by the Plain Township Board of Zoning Appeals to modify the application that applicant Joseph Nemeth construct a chain link fence running from the driveway of the Millers, and we can put this is, to connect with existing fence owned by Mr. Neiman. The Millers have agreed to reposition storage shed to make fence possible. Anything I'm missing?
Mr. Neiman?
I guess it's questions for Tom. The setbacks, am I allowed to put it on the line, or how do you want it, or what are the setbacks of the fence? I don't know what the setbacks are.
We don't, issue permits for fences.
Oh, okay.
So the only requirement we have is that it, is, let's see, it's in front of the house. That's 3 foot high in front of the home.
She said 4, I think. That's not.
Your fence is 4 feet tall,
Yeah.
but it's not from the front of her house, it's not from the front of the street,
No, it's just.
it's behind her driveway back
Guys,
to
one
you,
at a time, please.
back to you.
So it is, it's,
I just want
It's
to know
on
if I
the
put on
side
the
of
property
your
line, because
property.
it's gonna be hard, just letting you know, I'd like to take the trees down, which are on the line anyway, those old pine trees, because, it's gonna be hard to start putting posts in trees or there, you know what I'm saying, because they're big.
Yep.
So I take the trees down, put the fence on the property line, everybody's happy. That's what I'm looking. Take the trees down, put the fence down on the property line. Is that fair? Or, I don't know if there's a setback, that's why I asked.
we have no setbacks for.
Okay, I'd just like to put on the property line, 'cause that's, or 6 inches on my property, or on her property, whatever, I don't care.
If it's on the property line, I would assume it's both of yours.
Yeah, that's exactly right.
You have responsibility to keep.
I just don't wanna trying to not have hassles later, I wanna take the tree, because there's roots everywhere. I can't, when you start trying to put posts in, I just wanna I'll pay to have the trees taken down. Put the fence in on the property line, I have surveyor come out, fence will be on the property.
Ma'am?
As long as, admittedly, we do not have the capital to assist with that, so as long as it's in writing that those trees would be removed at their expense, that is A-okay with us.
That's what I said I would remove, I would pay.
You heard it.
Yes.
Let me reread this now. Appeal number 1393-24, applicant and owner Joseph Nemeth, P.O. Box 427, Akron, Ohio 44309, Joseph and Helen Nemeth, 5430 Middle Branch Avenue, Northeast Canton, Ohio 44705. Applicant is requesting a variance for a home occupation at 5430 Middle Branch Avenue, Northeast Canton, Ohio 44705. Parcel 52-17924. This relates to section 702.2, B4, conditionally permitted uses. Home occupation subject to subsections 115 and 122. Now therefore be it hereby resolved by the Plain Township Board of Zoning Appeals to modify the application so that applicant Joseph Nemeth construct a 4-foot chain link fence running from the driveway of the Millers to connect with fence owned by the applicant. The Millers to reposition storage shed to make fence possible, and Mr. Nemeth to remove pine trees at his expense. That's the motion.
Is there a second?
I'll second.
It's been moved and seconded. Is there any further discussion?
None here.
Roll call vote, please.
Ms. Zerlo?
Yes.
Mr. Reichel?
Yes.
Mr. Beck?
Yes.
Mr. Sutton?
Yes.
Again, with the modification.
Yeah.
Yes, ma'am.
So what does this resolve? This resolves the issue
Of
of,
safety of her child.
okay,
It is upon Mr. Nemeth to instruct, and I will say, I've got no authority to issue this, but those people that use your place, tell them to slow down.
Is the conditional use certificate, it is granted now, correct?
Correct.
could I ask one question about that? From
Yeah.
when you all were reading, the information about the conditional use, there was something in there about, I mean, it's a family thing, and that people, other people can't be coming, you know, it can't be like the hub for a business, because you read something that said other people couldn't be involved, that were not,
I didn't read that.
whoever read it out loud read that.
He read the whole thing.
The board has made a decision, man.
Next.
We
You can leave.
call me Monday because I'm gonna have a hard time getting paperwork together.
We have a second appeal. Appeal number 1394-24.
Ma'am, ma'am,
Ma'am,
please exit.
we have to go outside,
Disrupting
folks.
the hearing.
We're still conducting business.
Appeal number 1394-24. Applicant owner Brian Spring, 8234 Pittsburgh Avenue Northwest, North Canton, Ohio, 44720 / Hurricane Holdings Ltd, 7907 Elmhurst Avenue Northwest, North Canton, Ohio, 44720. Applicant is requesting a lot split, which will require 3 variances on property located at 7907 Elmhurst Avenue Northwest, Canton, Ohio, 44720, parcel number 100169224, and parcel number 5216191, which are both zoned rural residential RR. The lot split will create a less than 1 acre lot. The minimum lot size without central sewer in an RR zoning district is 2 acres. Both lots require a 100-foot frontage, and the applicant provides 98 feet and 50 feet frontage on the parcels. Section 701.3, minimum lot and yard requirements. If no sanitary sewer is available, the minimum lot area shall be increased to 2 acres. The applicant is requesting a .8029 acre lot. Lot frontage in a rural residential district is a minimum of 100 feet. The applicant is requesting 98 feet frontage on one parcel and 58 feet frontage on the other. The property is zoned RR Rural Residential District and is located in the northwest quarter of Section 4. Okay. Someone's here to speak on behalf of this. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name and address, please.
Yeah, Brian Spring, home address 7685 Elmhurst Avenue Northwest, North Canton, Ohio 44720. Okay? And I'll be referencing this, which I think you guys have there as well. So the drawing. So this is 2 parcels that are adjacent. Currently, the one parcel has 98 foot of frontage, and it has about 3 or almost 4 acres on it. And it's, has a small house on it. That's the one to the north. And then there's a second parcel that's to the south, adjacent to it, that currently has 50 foot of frontage, and it's just a vacant lot. So what we're trying to do here is reparcel these so that we have the house that's existing, which is a small 2-bedroom home, with the current 98 foot of frontage, that would only be 0.8 acres.
I'm
So
sorry, 0.828.
0.8029 acres
Right.
would be with that, with the house, and then we would have a separate lot, parcel number 2, that would be 4.2664 acres, that would be available to build another home on, and that would have a 50-foot frontage, which would essentially be used for the driveway that accesses the larger lot back in the back that has about a 277-foot width where the house would be built. So that I think we're basically just exchanging the small lot for the big lot and the house, and not changing again the frontage. Although they currently are less than your 100 feet, and they remain less than 100 feet, but not be changed there. And then regarding the 2-acre septic, we have provided you, we have approved plans from the Stark County Health Department for a new septic that fits on this 0.8029 acre lot. Actually, they just started work on that yesterday. That's gonna happen regardless of what happens here, but that it was a bad septic tank or a system from the original house built in 1960, so we are replacing that with a new septic that, again, has been improved for the smaller lot.
Does anyone have any questions for this gentleman?
We have to ask if there's anybody else to speak in favor or against.
Is there anyone else to speak in favor? Okay, anyone have any questions for this gentleman?
I have none.
Thank you, sir. Is there anyone to speak against this appeal? I see no response. Any questions from the board to anyone?
I have none, Mr. Chairman.
None? May I have a motion, please?
I'll do it.
Go for it.
Appeal 1394-24, applicant owner Brian Spring, 8234 Pittsburgh Avenue Northwest, North Canton, Ohio, 44720/Hurricane Hole Holdings LTD, 7907 Elmhurst Avenue Northwest, North Canton, Ohio, 44720. Applicant is requesting a lot split, which will require 3 variances on the property located at 7907 Elmhurst Avenue Northwest, Canton, Ohio, 44720. Parcel number 1001692 and parcel number 5216191, which are both zoned rural residential RR. The lot split will create a less than 1 acre lot. The minimum lot size without central sewer in an RR zoning district is 2 acres. Both lots require a 100-foot frontage, and the applicant provides 98 feet and 50-foot frontage on the parcels. This is section 701.3, minimum lot and yard requirements. If no sanitary sewer is available, the minimum lot area shall be increased to 2 acres. The applicant is requesting a 0.8029 acre lot. Lot frontage in a rural residential district is a minimum of 100 feet. The applicant is requesting 98-foot frontage on one parcel and 50-foot frontage on the other. Now therefore be it hereby resolved by the Plain Township Board of Zoning Appeals to grant the request.
Second.
Any further discussion?
Mr. Beck, second.
Yep.
Any further discussion?
I have none.
Roll call vote, please.
Ms. Cernova,
Yes.
Mr. Reichel,
Yes.
Mr. Beck,
Yes.
Mr. Sutton.
Yes. Okay, that's the second appeal.
Call the office on Monday.
Very good, thank you.
There is no meeting
fast.
scheduled for August, so maybe September. I will entertain a motion to adjourn.
So moved.
Second.
Roll call vote.
Ms. Cernova,
Yes.
Mr. Reichel.
Yes.
Mr. Beck.
Yes.
Mr. Sutton.
Yes.
Well, when it was the night that we needed souls and pussy,
Boy.
it was tonight. Yeah. You've seen this many, many times.
Oh, yeah.
Thank you, sir. I appreciate it.
Uh,
Good night.
you like to see attorneys challenge one another.
I appreciate your
I see
introduction.
my attorney sitting in the car.
Oh.
Let me know if there's
Bye-bye.
speeding or.
Time for your judgment.
I did
Yes,
take
it
videos,
is.
so admittedly,
Who
that's
knows?
one of the reasons yesterday where
Maybe
clearly
you
we're not
take a shortcut
doing
out
the
that way.
5 to 10 miles an hour speed limit. But,
You heard me put on the
Okay,
record.
sir, thank you.
I was supposed to slow down.
do you know how much time we have to get the shed built? I'm a
That-
little concerned about that, so while the front line are maybe financially in a little different position than this young family.
Understood. Well, hopefully you guys can work together
Happy
now.
Fourth, everyone.
Yes,
Good idea.
be safe.
Amenable.
Yeah, I
Ask
don't know
him.
who the
I
other,
tried.
admittedly, I've never spoken or seen the other lady who has.
It's a hot city, our participants.